So, good morning, welcome everybody. I'm delighted today to have Arabella Tresilian as my guest for her care conversation. I've got my cup of tea. So.
Yeah.
Very organised. Oh, and there you go, excellent. Got the important stuff sorted, haven't we? So
Yeah.
that's ideal. So, right-ho, over to you. Tell us about yourself. Tell us who you are, what you're all about.
Thank you, Heledd. Well, it's lovely to be here. Thank you so much for having me. So I'm a mediator. So what I do is dispute resolution, and I specialise in public services sector, so particularly health and social care. I have a particular interest and particular experience in neurodiversity, mental health and disabilities. So I came to mediation through two specific routes, really, two perspectives. One was many years as a very grateful beneficiary of services within health and social care, both for myself as a patient and service user, but also for family members. So I was a family carer for some 15 years. Okay. So navigating certain services was quite complex. We all received amazing care, but it was complex. At the same time, because our lives were all health and social care, the work that I got and was doing for many years was sort of management consultancy projects, research projects within health and social care, and interim management posts. And one of my roles was an interim management post where I was, one of the departments I was managing was the complaints department. Mm-hmm. And I was really shocked at how long complaints sat within that department, with both professionals and patients, families in limbo, while it was determined who had been at fault. And even when things were determined, there was really no resolution for anyone, and people just felt drained and exhausted. So that was really kind of the tipping point that led me to think, gosh, couldn't we have something different in terms of resolving some of our concerns, complaints, but also some of the court-related difficulties. So that's when I kind of decided to become a mediator. And there are a couple of other things that I kind of bring. One is that I spent many years working in patient and public participation and involvement and engagement. So I'm really passionate about the voice of the person at the heart of a dispute. And I like to think that I can sort of help enable kind of equitable access, which can be difficult. You know, it's really difficult to find our voice when there are disagreements around, say, our care arrangements. But the other thing is that for many years, I've taught and been an advocate in the area of mental health. And I think over the pandemic, taught nearly 3,000 people about mental health conversations, mental health first aid. So the other thing that I love about mediation is that we can create psychologically safe spaces in which to talk about really difficult things. So that's my kind of how I got there.
Wow.
And what I bring. Yeah, that's the sort of starting point.
Fantastic. I mean, yes, I the sort of word I was picking up there is exhaustion, and that yeah. Sort of, yeah. Being a carer and navigating is just exhausting. I mean, yes. And you think about all the people you end up talking to and all the things you need to learn, and you suddenly have to become an expert in everything. Why, or overnight almost, don't you? You sort of end up having to sort of learn about whether it's an illness, or whether you have to learn about that. You have to learn about the treatment. You then have to learn about how that should be treated, and then that's sort of medical side, and then you get all the sort of social side, and then it's a bit like life doesn't stop, does it? There's also a life going on outside all this, and I often think it's a bit like bereavement when people say, I can't believe the life's still happening when I'm so bereaved. To be a carer and have to just function is incredibly hard. And so, being a lawyer, we end up sort of talking to people where perhaps they're seeking advice, but also things go wrong. Sadly, we know things go wrong, don't they? And all a big advocate of not going to litigation where possible. I think my favourite phrase is litigation's a bit like dancing with a gorilla. You stop when the gorilla wants to stop.
and tread on your toes.
Yeah, absolutely. And these are people coming in quite gung ho, aren't they? I want my rights. And go, well, hang on, let's take a step back. Because litigation is also exhausting. It can be expensive. And there is a real push, isn't there, towards what are you trying to achieve? Is there another way of doing this? And for me, I think I'm fortunate that I've not had to have personal involvement in mediation, given the work I do, but obviously know about it, and understand what it is to an extent. But it is very much a case of, look, have you thought about mediation? And before we go gung ho and charging off to court, and get into your gorilla tango scenario, what about mediation? So if I was to say to my client, have you thought about mediation, and I get in touch with you, what then? What does that look like?
Great. So first of all, it's important for you and your client to understand what we mean by mediation. So a helpful way to think of mediation is simply the phrase assisted negotiation. So when things are stuck and everyone has kind of done their best, you may need a trained, impartial, independent person who can help assist a negotiation. So this can happen at any stage of a dispute. And we always say the earlier, the better. So, if there are things that are difficult, for example, often, lawyers might try a round table meeting, but what research shows, and the Public Law Project is really good on this, they've got some really good research on mediation and judicial review. So I've done several judicial review cases. Okay. What they say is that round table meetings often, they are difficult because it's not entirely clear who is guiding it, and it's not entirely clear always what has been agreed. So with your mediator, you've got someone who is really focused on supporting everyone in the room or the rooms, and who is really set on clarity around what is being discussed and what is being agreed. So there are kind of 4 pillars to mediation that make it a kind of safe space to enter. And so hopefully it's not like dancing with a gorilla. So the first thing to understand is that mediation is confidential. Okay. So once you, the very first thing you do once you agree to mediation and you've appointed your mediator, is everyone would sign an agreement to mediate, which is a confidentiality agreement. Okay. And that means that if, for example, there are legal proceedings underway or in the future, everything that is discussed is without prejudice. So it can't be taken forward. So that means that you can discuss things at, much more at greater liberty than you might in a court setting. But it also means that your agreement is confidential as well. It remains private. So the second pillar is that your mediator should be impartial and independent. So they're not rooting for any side, they are rooting for you to find a win-win agreement. The third pillar, and this is for now, is that mediation is voluntary. Now there's some real questions in the air around whether mediation should be made mandatory. Certainly in the family courts, there's an obligation for divorcing couples to explore mediation. But classically, mediation is voluntary. So people are there because they feel that they want to be there. And then the fourth pillar is around self-determination. So your agreement should be self-determined. The mediator isn't an arbiter and isn't going to make a decision. There are some types of evaluative mediations, but classic mediation will support you, both or all the parties, to find their own agreement. So, and on that base, it's important that you have the right people in the room, people with authority to settle. So if there are financial aspects involved, it's really important that people with financial decision-making are involved. So the first step is making sure that everyone is on board, that you've chosen a mediator that you think is going to be able to support and meet your needs, that you've got the right that you've got the right people in the room. So some particularly early mediations may or may not have lawyers in the room. And that's really a decision for everyone to make. But certainly once legal proceedings are underway, then it may well be that solicitors, barristers, and other professionals are in the room. And that's really helpful, because if you are mediating once legal proceedings are underway, for example, after a letter before claim, you know, initiating a judicial review, or once the court of protection proceedings are underway, then you've got the opportunity to see whether, with the sort of collective brain power of everyone, whether, and goodwill, whether you can find you know, a solution yourself without it needing to you know, sort of have a final adjudication. But equally, some you know, there are court-ordered mediations as well that will sort of be coming out of a court case. So mediation can happen at any time, and the thing that we like to say is that it's really flexible. It's a flexible process that should meet the needs of everyone involved, and that particularly means if P, or a person in, you know, at the heart of a court of protection case, is involved, or there's a possibility that they might be involved, within mediation you've got all sorts of scope for their voice being heard as well.
That's really interesting, because as you say, sort of, I know the family court's keen on sort of mediation to try and, you know, take the heat out of things and sort of try and, you know, as you say, sort of push things in that direction first wherever possible. The court protection mediation is interesting, isn't it, as you say, because there's an incapacitated person at the centre, and their voice may well get lost in the proceedings, because, you know, if you have contentious court proceedings, then you've got people who are obviously very unhappy for one reason or another, and then it's a case of how do we have that dialogue between people. But I'm really interested in, when you've got that incapacitated individual in the middle, how do you make sure that all the competing interests are heard and theirs?
Brilliant. So you can still have those elements that you'd be familiar with, litigation friends, advocates, etc. And the official solicitor can be involved as well, as to help represent that individual. So all of those individuals can be part of the mediation, but equally, because you can stagger the process of a mediation, it may be, and particularly now that we're doing things online, you know, now we're doing mediation online, it's much less common, I would say, to have a classic full day mediation where we're just going to crunch everything out. So it might be that you'd have, you know, some initial meetings with the various parties, including P if that felt appropriate or possible. But then you might have an initial joint meeting, again, with or without P being present, and you might make some initial agreements that then you would want to test out with P in a more relaxed setting, with the right person being able to explore, you know, the person's responses to what is shared with them, and be able to bring that back to a follow-up joint meeting. So that's a way in which we can kind of slow down the decision-making process, so that it goes at the right pace for everyone's voice to be, you know, ever part of what we're discussing, and you know, really at the heart of what is being agreed. There's a kind of like, you know, checking in process that can happen either within meetings or separate to meetings, whatever meets that person's needs and makes things most accessible for them.
I'm really interested in hearing you talk about actually that being able to do things online is a good thing, because, I mean, as you say, sort of, whilst not having been personally involved in mediations, we've definitely had our offices have lots of mediations going on, and it's that sort of, you know, it's that scurrying between rooms, and, you know, and they just go on for hours and hours and hours and hours, and, you know, we're sort of everybody in the office is sort of trying carefully, sort of, you know, gingerly work their way around the building and make sure we don't disrupt people, and, you know, clearly there's very intense conversations happening in corridors and spare rooms. So, you know, how has it worked, you know, in a remote setting? I mean, you know, because is it easier, is it harder? I mean, what would you say?
my overall reflection is that it's actually easier. For many individuals, there's a lot more psychological safety around being in the comfort of their own home.
Okay.
It's easier to get people together, particularly if you've got people across the country. So, you know, a date is where people can join. If they're not having to travel, it's much easier. And you're not trying to necessarily get everything done in that one day, because as you say, if you've got everyone in the office in the different rooms, and you've got some shuttle mediation going on, and maybe that comes back into a joint meeting and so on, everyone is really super invested in getting an agreement by the end of the day, but people lose energy. And my feeling is that, you know, a lot of the work I do is involving people with additional needs, disabled people, people with autism or mental health needs. And I feel, and as a person with a spectrum of those conditions and diagnoses myself, you know, 8, 10, 12-hour meeting is too much. It's just too much to ask of any of us. And we get the law of diminishing returns. By 8 o'clock, everyone is starting to sort of be on their knees in the evening. So actually, why don't we have a couple of hours just on Zoom? No one has to travel. We've got a really clear agenda of what it is that we're going to look at. And I'm always really, and mediators are, super future focused, solution focused, especially once everyone's voices have really been heard and their concerns have been heard. So you can kind of like narrow the scope for small meetings so that it's more bite-sized and more manageable. And I would say that is something that online, you know, kind of us all being more familiar with online meetings has facilitated to the good.
It's really interesting that, because, you know, sort of had a first face-to-face meeting with a number of my colleagues yesterday, and it's like, oh gosh, it's really nice to see you in person. Thankfully, we weren't, you know, in any sort of disagreement. So I can personally see that if you've got that sort of comfort of your own home, and perhaps if you're nervous about going to a mediation in the first place, it seems a lot less scary to be able to do it from home and be involved. And again, you know, this sort of feeling when people are mediating, you know, that there's a lot of very serious faces and lots of sort of, you know, that scurrying. So actually to be able to take that out of the mediation, that sort of visible, I think I can really see that would be helpful.
And you can also still, I mean, you know, Zoom has breakout rooms, so you can still very comfortably move people into separate rooms, you know, to speak with their lawyers or to kind of like think about what's been said. And as mediators, we can go into each room. Often I will co-mediate, or I'll have an assistant mediator, or I'll be an assistant mediator. So then it's, you know, you're still getting the mediators going across to the different parties, typically too. But, you know, I think I've had several, you know, I've had mediations where we've had 4 or 5 different parties, each of which has 2 or 3 different people. So, you know, it's not unusual to have 17 to 20 people in a mediation.
That many.
And actually, if everyone can go back to their rooms, but if you're trying to get, you know, 4 or 5 different meeting rooms available, then, and everyone's travel expenses, costs are going up. And you're putting a lot of pressure on getting everything done in one day. So yeah, breakout rooms facilitate shuttle. They also make it really easy if people are getting upset or emotional, for it to be very simple to take a break in privacy. It's, you know, and I just think that's crucial. One of the things about mediation that people often say is, I don't know if I can do it because I think I might be emotional or I might cry. And, you know, actually mediation makes space for emotions. It makes space for you to be able to say, not necessarily only you're kind of like, these are our points that we want to get across to kind of evidence what we feel, but this is what I want to say to you, other person across the table. This, you know, the impact, the emotions, and again, that private space allows that to be okay.
It's having that space to have your voice, isn't it? And you know, you said at the beginning, empowerment. You know, it's a good word. Sometimes, you know, I wonder if it's overused, but I think, you know, in the right context, it is absolutely what people should be doing. You know, that sort of moving towards people getting their voice, getting their points across, getting themselves understood. So you mentioned you sort of, your your areas are sort of mental health, court protection, local authority. I mean, these are all quite unwieldy areas at the best of times.
Yes.
I mean, what would you say perhaps you've learned from dealing with these big institutions? Because I think there's obviously the people, the individuals, but then if you're liaising against an institution, if you're mediating, sorry, with an institution, a local authority, a clinical commissioning group, the court, that's big. Then you've got representatives of those institutions. So I'm really quite interested in sort of, how does that work? I mean, how does that actually work in practice when you're mediating with the local authority?
Brilliant. Well, so a few things. First of all, whoever it is from the local authority, by the time, and you might have various people from whichever institution, whether they're the CEO, the financial director, the head of this or that, by the time they come into mediation, and I suppose it's the same in court, they come as a human being as well, pretty much exhausted. Often a dispute will have been running a long time. So everyone in the mediation is there kind of as a human in their own right as well. And so we want to take care to tend to everyone's kind of emotional and psychological needs, wherever they're at in terms of the power balance. But we are really interested in power balance in mediation, because we're really aware that even if it's just two neighbours in dispute, you can get the sense that there is a power imbalance. So we do quite a lot to make sure that if there is an individual, say, who is in dispute, or a family, that they feel that they've got representation, support, so that they do feel confident that they've got kind of the right people there for them as well. And we might take some care to make sure that we've only got the people needed in from the organisation or the authority, so that we don't have huge numbers, kind of disparate numbers per party. But the other thing, I think, that we have a special privilege, really, and that's with a small p, as mediators, is that because we get to speak to parties both in the joint meetings but also privately, there's quite a lot that we can do to coach professionals, say representatives of organisations, to be able to present themselves in a way that will be heard and accessible and that will be conducive. But we can also work with our clients who are family members, patients, carers, employees, whatever it might be, who may have less sort of power, as it were, to help them find ways to articulate feelings, needs, impacts. And I work a lot with requests and offers. Often we come to mediation, we're really clear about what has gone wrong, but we're not so clear about exactly what it might be that we're either requesting or offering. So that's something that we can do kind of offline in privacy with the different parties to help them really clarify. And whenever advising, and if people have got their advisors there, but as mediators, we get quite good at understanding what will land in a joint meeting as something understood or actionable, or kind of something that you think, yeah, this could be taken forward as a kind of an actual action that everyone could agree to. And I suppose the last thing I'd say on this is that I think and I'm sure many of my mediation colleagues are also really keen on mutualizing. So that can be about finding the language that retracts blame from one person to another, but is much more about, we all agree that what we want is, so we agree our shamed aims are, and we agree that in the future we will. So it's not coming out at the end as a list of, kind of things that this person will do or that person will do. There may be very specific actions that individuals will do, but we're much more helping everyone involved discern and describe their collective vision of how they're going to move forward together, or how they're going to part ways if it's actually the end of a relationship, but how that will be done amicably to the degree that is possible, and leaving everyone feeling a sense of I felt heard, I felt my needs were understood, and I feel like I can, this is an agreement that I can work with.
Okay. So would it be correct to say that there's actually, people will say things, of course people will talk, and the purpose of mediation is talking and hoping resolving. Is it a case that you have to listen to what's not being said a lot of the time?
Yes, yes, absolutely. Absolutely. And people give, people, you know, as you'll know as well, people give signs of distress. They give signs of agreeing to something that you can tell they don't really agree to. So yeah, we've got those opportunities to kind of pick up, whether in the room or in the private room, you know, you said this, but I wasn't 100% sure if you were comfortable with that. So the kind of reality checking of a mediator to make sure that we've really bottomed out, that people are genuinely feel signed up to what's been agreed, does definitely take the, not just what is said, but what is unsaid. I really agree.
Yeah, and you know, it is. I was in a fairly interesting sort of client meeting the other day, not remotely contentious, and it was just talking and talking and talking, and I was like, hang on, reverse. You just said something quite important that completely skews everything we've talked about. And I still explained back to him what he just said. You see the penny drop, and it completely, you know, just massively altered the course of our meeting. And I always think that's really interesting when you know it's the ability to listen, isn't it? Which is actually listening properly, and listening to what's being said and not said is hard.
Yes, yeah, absolutely. And bringing that kind of really compassionate awareness to the fact that when we're trying to express ourselves about something that's really important to us, often our brain is in a real kind of fight or flight state. The amygdala has been triggered. We're in a really alert state. And what we know about the brain is that when we're in that state, that what I call kind of amygdala state, then we actually have difficulty accessing the prefrontal cortex, where we do our decision making, our rational thinking, our communication, but also the prefrontal cortex does our kind of like polite talking to each other, and our morals and our manners and our stuff like that. So yeah, if we can be an extra listening ear with that kind of, you know, universal positive regard, and understanding that if someone is saying things that don't make sense, we can help them articulate it. But also that if they're coming out in a kind of an aggressive conflict style, that we can understand that, you know, the brain finds it really difficult to be in conflict, and, you know, we can find ways to sort of temper that. Mediation starts with ground rules as well. So that's a really kind of important thing that we agree, like, not, people won't talk over each other, people won't, you know, shout, people won't, you know, I do a lot of community mediation where neighbors, or, you know, are really cross with each other, and they've maybe already kind of hit each other across the fence.
Ooh, gosh.
So we, you know, we just make those things clear. But also, and I love what you say about the noticing, the aggressive conflict style is one that we're familiar with, but also the avoidant or accommodating conflict style, where we don't want to say anything or we don't want to go there, is another really important aspect that we can work with and help someone feel confident to sort of articulate, to kind of speak for themselves, whoever they are in the mix.
Yeah. I you know, I mean, you must have immense patience, I have to say, that, you know, to not want to get in and fix. And I think, you know, as a lawyer, I get, you know, my role is, please give me advice what to do. And I think I would find it quite hard to have to sort of go, well, yeah, you could do this, you could do this. You know, it's that sort of, I think somebody said, it's a bit that sort of matrix, red pill, blue pill, what would you like? And, you know, we can do that to an extent, but we will sort of maybe nudge people in a certain direction. And ultimately, I am here to give advice. And mediation is not giving advice in the same sense. It is facilitating, isn't it? And finding that way through. So, do you ever find, you know, and is this part of your training, that, you know, you have to sort of learn to take that step back learn to have that oversight and not want to go in and fix?
Hugely so. Hugely so. Very often you've got this kind of dilemma because both parties or all parties have kind of like shown you what's under the bonnet for them. Mm-hmm. So often you can see that they're actually really close together, but maybe there's one small thing that neither of them want to talk about. And you know that if they would talk about it, they would get a lot more understanding. So you can coach as to, you know, help people kind of check what would happen if you mentioned X, or what would happen. But their will is the most important thing. And you know, I reflect that as a mediator, it's really important that I don't get attached to people having a successful outcome or successful settlement, mm-hmm. because I think there is a time and a place for everything. And for some people, they're not ready to let go of their hopes of how things might be, or actually what they're experiencing is maybe it's a family member who's experiencing anticipatory grief around the loss of an elderly parent, and actually them kind of holding to a case is one of their ways of showing their love for their parent who's at the end of life. You know, that's what it is. And
that's immense.
It's immense. So, you know, us getting an agreement is, you know, maybe that will happen next year, or maybe there, you know. But the other thing around advice is that, you know, some of my cases have lawyers present and some don't. Mm-hmm. And when I'm always delighted when we have lawyers present, because I know that the parties have got someone giving them that advice, looking out for their best interests for them alone. Okay. So as long as you know, that's part of the mix, that, you know, I would worry if I felt that someone was making decisions that either I wasn't sure they understood, and that would mean that we would stop and we would make sure that they got advice. But yeah, I think the only thing that I would say as kind of advice for lawyers coming to mediation is that it's really helpful for you to prepare your clients that this is not going to be a case of a win or a lose, or we just need to put our case clearly enough and the other side will back down. But what we're looking for is to understand each other better, mm-hmm. at a really kind of human level, and hopefully they will understand you better and you will understand them better. And then we're going to make an agreement that works, that everyone can live with. Yeah. And that is essentially, mediation is often about a compromise, but it's about getting unstuck and being able to move forward. So as a lawyer, if you can help your clients understand that's what we're moving towards, or what's on offer, and also help them to be able to think about how they will articulate what they want out of mediation, then that's a great start. And then you're there to sort of support them all the way.
That is great, isn't it? Because I think, you know, we are, as lawyers, we're advocates. We have a client. Yes. You're my client. I'm on your side. You may not like what I have to say, but, you know, this is for you and you alone. And, you know, we're all drummed into it from day one. It's about, you know, conflict of interest. You know, you can only act for your client, like it or not. Yes. You know, go and get separate representation. You know, you need to be advised. So I like the fact that, you know, we must be the only few people who actually like seeing lawyers. And so, you know, we're there advising behind the scenes, you know, and that is our role, to say, you are my client, I will advise you. So it is interesting that you can then bring this sort of aspect that we simply cannot, because we have to act for our client, and there is whenever, you know, there is inevitably another side somewhere or another. We can negotiate.
Yes.
We can say, hang on, you didn't do that right, and we'd like you to remedy that. Yeah. But actually, as you say, what is the outcome you're looking for? Yeah. You know, because
and typically, you know, where lawyers are involved, they will write the settlement agreement. That is, you know, if not, then I help the parties write it. Mm-hmm. But another reason it's wonderful to have lawyers is that collectively they will write the settlement agreement. So that allows me, as someone without a legal background, to feel really confident in what's been agreed. But also what lawyers often reflect on is, my gosh, the level of detail we can get into in this agreement around, sometimes it might be things like visiting protocols, or, actual timings where people will visit, and things like, which I know the court can give comment on as well, but things like whether it will be a visit on the doorstep, or which room it will be in, or what we'll say to each other when we meet each other, things that maybe would not have come up in court, but actually in the mediation room are really important. I go and visit my mother in her home, and my brother never says hello to me. We discussed that. What would it be like if you said hello to your sister when she came to visit? Oh, okay, I'll do that, but as long as she wears a mask when she comes in, because that really annoys me when she doesn't. Great. Does everyone agree with that? Yeah. So it's the little things, the nuggets, that actually make everyone feel like, oh yeah, I can move forward with this now. So it is that mixture of the kind of the legal, that legal support that you bring, but also all of those tiny details of the things that really matter to individuals. And
it's that tiny stuff, isn't it? It's that tiny, apparently insignificant stuff that actually it's just awful, isn't it? That is awful to the person, and that people get offended and people get hung up on it, and actually it suddenly becomes very high level. And it sort of escalates to being, right, that's it. I know my rights, and I know this. And, sort of doing a lot of work with colleagues who do, sadly, clinical negligence work. And sometimes all I wanted was a sorry.
Oh, my goodness. Yes, the sorry. Oh, my word. Thank you for sharing that, because actually within that confidential space of mediation, that is one of the things that people can say without feeling, oh my gosh, I'm admitting liability, because I'm really sorry that happened, or I'm really sorry there was a 2-week delay. This is why there was a 2-week delay for, this assessment, or yes, we did lose this piece of paper, or, and that's why this happened. So yeah, it's good.
So I mean, it's great. I think it's absolutely phenomenal. We've got, as a lawyer, we've got this facility in mediation, and I know that the court protection is really moving towards that being a really intrinsic part of it. Family, we know, and you touched upon sort of talking about in the workplace and conflicts and resolution. And I also really like the fact that you're coaching people to say, actually, if you find yourself in this situation, this is your toolkit.
Yes. Yeah, and we do single party mediation, which is where if the other party doesn't want to get involved, you can work with just the professionals or just the family to help them basically organize we need help organizing our thoughts. It's about human psychology, how we work together in a collaborative way. Most of us are never taught it. So yeah, we all need that help, I think.
And I think it's nice, and it's nice having different perspectives, and it's nice having different language and understanding the language. And I think, so just touching on your sort of thing about settlement agreements, and people sort of say, oh, lawyers use loads of words, and unfortunately lots of words are sometimes what you need to make something very clear.
Yes.
And I know it seems counterintuitive, but actually missing out, having very, very tightly worded documents means that you can go back when the nuance is lost.
Yes.
And it's that meeting is lost in the mist of time, and you can go back to that document and go, fantastic, a really well drafted document is an absolute godsend.
Yes.
And so getting those agreements right, and getting those agreements right at the end of the mediation might not use the same language as in the mediation, but actually it's all part of that journey.
Yes, exactly. And you get that sense when people have this feeling that we've arrived, people get their shoulders go down. And you can, and this is another thing I love about online mediation, is that we can draw up the document in front of everyone's eyes and get the wording just right. So my degree was in English literature. I'm really into the correct word for the correct thing, as you say, because our language is really nuanced. So what is if that word is jarring for one person, what's a word that feels like it's more representative of what we've discussed? And then you get to that point where where everyone feels, yeah, we've done the work. That's, and then that can result in, court proceedings being stayed. It can kind of turn into a consent order. It can play its role within any court proceedings that are ongoing, with, under its confidential terms.
Which is, it has to be the right way forward.
Yes.
Absolutely has to be the right way forward.
Yeah.
Well, I mean, but brilliant. I mean, that's given me a huge sort of insight into your world, which I know about from a sort of like, well, I know about mediation because I know, but it's sort of a thing that happens over there.
Right. Well, come on in, do some of it with me.
I mean, thankfully, I mean, happily haven't needed to send people to mediation, but it is something that we are always talk about, and we always say to people, and I think you and I talked about this, that actually a lot of time the mediation I may see is when it's estates disputes, and that's grief and money, and that's potent.
Yes, absolutely.
and that's a whole other that's a whole other ball game, isn't it, from sort of what you're talking about. But I really like this talking. I really like this knowledge and this knowing, and that's absolutely fantastic. So thank you very much from me. Has anybody got any questions? Very quiet. I see Ian's had to leave us, so thank you, Ian. You're not here, but you might watch the recording. But if anybody's got, if anybody who's watching this wants to sort of contact Arabella, we can absolutely, we will circulate her details and make sure that she is available. And yeah, I want to say a huge thank you from me. I mean, it's been absolutely fascinating, listening to you talking about how it works, what it looks like, what it feels like, and it really brought it to life for me. So thank you very much. Thank you for your time today.
Very much for having me. Thank you.
All right then. Bye bye now.
Bye all.